This is the DEI panel. We are fully aware that we're standing between you and cocktail hour, or dinner, or a workout, or whatever your evening plans are. We've got a terrific panel here, a lot of current material, so we'll hopefully keep it interesting and keep it moving. I'm going to let the panelists introduce themselves in a minute. For the continuing education words, the first word is phone. Phone. All right. To my left, Sophia Martos, would you like to introduce yourself?
Hi everyone, good afternoon. It's a pleasure to be here with you all today, and especially to cover such an important topic. My name is Sophia Martos. I'm a partner in the ESG and Impact practice at Kirkland & Ellis, and I'm based in Los Angeles.
Hi, thanks for having me as well. My name is Rana Ismaili. I'm a partner at Sidley Austin here in Washington, D.C. I'm a partner in our Securities Enforcement and Regulatory Practice Group. I joined Sidley from the SEC coming up on 3 years ago, where I was an assistant director in the asset management unit in the Division of Enforcement. My practice is a combination of regulatory advice and counseling for our asset management clients, and I do a fair bit of SEC enforcement and exam work as well.
My name is Seth Waxman. I'm delighted to be here to participate in this panel. I'm a partner at WilmerHale. I started out for the first 20 years of my career, I was a trial lawyer here in Washington, D.C., mostly during corporate white-collar representations. I then went to the Justice Department and served in a number of roles, including as Solicitor General of the United States. And when I came out back into private practice, no one thought of me as a trial lawyer anymore. I was an appellate and Supreme Court lawyer, which is a lot of what I do now. But I did, and I think the reason I'm on this panel is for 10 years, I tried, argued, and then briefed and argued in the Supreme Court the SFFA versus Harvard race-conscious admissions case, which has generated so much of the furor over DEI in private industry. So I'm very happy to be here.
Great, thank you all. We'll welcome questions throughout. Keep them coming either on the cards or on the app, and we will weave them into our conversation. Seth, I think we're going to start with you. I'll just point out that based on your bio, I think you've argued 85 or more cases before the Supreme Court, and that's roughly 85 more than me. So on that basis, I think we'll let you do a little overview of federal employment laws and civil rights laws and how that applies to what we're talking about.
So I just have to warn everybody that in the Supreme Court, there is a green light, a white light, and a red light. The green light means you can talk. The white light means you have 2 minutes left. The red light means you need to stop immediately, like in the middle of that syllable. And there are no lights here. All I'm seeing is a green light right in front of me with 46 minutes left. So I'll have to exercise some discretion. Lewis has strictly limited me to 5 minutes of introductory comments, so I'll be looking at the 41:20 mark. This is a program about developments and looking for developments and next steps. But I think we thought it might be helpful just to catch everybody up to sort of how we got where we are and what relevance, if any, the Harvard decision has for employers and private companies that engage in contracting. The short answer to that question is the decision in the Harvard case has absolutely zero relevance whatsoever to the topics we're going to be talking about today. But you would never know it because of the increased level of activity and threatened activity against private employers and private contractors in the wake of the Supreme Court's decision in the Harvard case. In the employment context, well, the Harvard case concerned the question of whether universities in trying to assemble a diverse student body across all human characteristics could, if it demonstrated that there was no way to achieve racial and ethnic diversity other than a limited consciousness of the race or ethnicity of the applicant, whether that was consistent with the Equal Protection Clause of the Constitution, which prohibits discrimination on the basis of race and other characteristics, and Title VI of the Civil Rights Act, which prohibits discrimination by recipients of federal dollars. In 1978, the US Supreme Court decided its first case of affirmative action in the context of university enrollments and university admissions. And by a 5-4 vote, it decided that if a university could demonstrate that it had a compelling interest in a truly diverse student body, it could take the race of applicants into account to the degree, but only to the degree, that there was no other way to achieve a genuine level of diversity in the admitted student body. This was an exception that the court carved out in the university admissions context. It was challenged again by opponents in a case called Grutter versus the University of Michigan in the early 2000s. A different 5-4 majority of the Supreme Court said, nope, that's right. This is permissible because universities do have a compelling interest in having a diverse student body, and if they can't achieve that in any way other than a limited account of race and ethnicity, that's okay. It was challenged again in the I think around 2014, 2015, in a suit brought by Abigail Fisher, who was not accepted for admission to the University of Texas. The court was again asked whether that was consistent with the Equal Protection Clause, because she alleged that she would have been admitted but for the fact that she was white. The Supreme Court again said, with a different 5-4 majority, no, this is entirely constitutional, and then queue up a lawsuit brought by a group called Students for Fair Admission against Harvard University, essentially asking the Supreme Court to overrule all of those precedents. And we tried the case. We got a 130-page decision by a very careful district judge saying that the way that Harvard was conducting its admissions program was entirely consistent with Supreme Court precedent. We got a 3-0 90-page decision from the Court of Appeals affirming that, and then the Supreme Court took the case. And what the Supreme Court said in the case is, they didn't say they were overruling their precedents, but what they said is, you cannot take race, quote, qua race, into account in making admissions decisions. You can, the court said, nothing in this opinion should be construed as prohibiting universities from considering an applicant's discussion of how race affected his or her life, be it through discrimination, inspiration, or otherwise. A benefit to a student who overcame racial discrimination, for example, can be tied to that student's courage and determination, or a benefit to a student whose heritage or culture motivated him or her to assume a leadership role or to attain a particular goal can be tied to that student's unique ability to contribute to the university. In other words, the student must be treated based on his or her experiences as an individual and not solely on the basis of race. Now, that is the current state of the law for university admissions, and I can't even count the number of university admissions offices that I've consulted with since last summer about what does that mean in terms of how we do this. The one thing I can say about the many, many employers who've contacted me, and there were, I think I was telling Lewis, I got calls from 40 different employers within the week of the Harvard decision saying, what does this mean? You know, what can we do? The answer is that employers were never part of this Bakke, Grutter, Fisher exception for college admissions. conduct that was illegal under the relevant federal statutes the day before the Supreme Court decided SFFA versus Harvard are still illegal. There are two statutes that are relevant here. Number one, the Equal Protection Clause has no purchase in the business environment because the Equal Protection Clause only constrains state governments. And nobody here, I assume, is representing a state government or employed by a state government or invests in state governments. Title VII of the Civil Rights Act of 1964 prohibits discrimination in employment. Discrimination, and employment is defined as to fail or refuse to hire or to discharge any individual or otherwise to discriminate against any individual with respect to his compensation, terms, conditions, or privileges of employment because of such individuals' race, color, religion, sex, or national origin. The other relevant statute for you is Section 1981 of Title 42, which prohibits discrimination on the basis of race in contracting. So, for example, in deciding who your suppliers will be, what characteristics will be determined in the context of that. So I see that I've already run over my imposed time limit by a little bit, so I'll stop talking now and we can get into the issue of, what does this mean? What can we do in terms of pursuing the goal of having diverse, inclusive workplaces, which has been shown over and over and over again to be a pro-competitive good for businesses.
Great, thank you, Seth, for that helpful overview. It's great to hear the context. And as we reflect on that, I'm going to give out the CE word one more time. I heard there was a question on that. It's phone, as in I dropped my phone on the floor. Phone, P-H-O-N-E. Rana, Sophia, any thoughts on what you heard about the law? It sounds like it's a pretty narrow decision in the Harvard case.
Well, yeah, as Seth said, it didn't directly impact corporate diversity programs, but I think because of the wave of litigation that we've been seeing since the decision and the way that the decision has really emboldened anti-DEI activists in the last year, we are seeing kind of greater concerns for shifts in the law in the medium and long term. And as a result, many of our clients are trying to sort out, what do we do in this new environment where the law hasn't changed, but potentially it could, right? Or the public perception of what is lawful may be changing. So I do have a couple of slides on that I can share. So in our practice, in the ESG and impact practice, we've been getting a number of questions as to, what does this mean for our corporate DEI programs? What does it mean for our investment strategies that may incorporate some considerations related to DEI? So I'm just going to share a couple slides, and my aim here is to leave you with some practical guidance. So first, we'll take a look at this great framework for understanding risk in the aftermath of the SFFA decision. NYU law professors Kenji Yoshino and David Glasgow created this red, yellow, green stoplight framework for understanding risk. And in the red category, the highest risk, this is basically quotas and set-asides. And these initiatives were unlawful before the SFFA decision, and they remain unlawful today. In the green category are practices and preferences that do not preference anyone, they're not targeted at specific groups. So there's kind of three main categories here. There's de-biasing initiatives that aim to obviously eliminate bias, such as structured interview processes, et cetera. They're initiatives aimed at inclusivity, such as employee resource groups or family-friendly policies. And they're universal programs, so programs that aim to benefit everyone, maybe a program on growth mindset or improving the review process generally for everyone. But I want us to focus most of our time here on the yellow category. So this category, is yellow. It's sending warning signs, and it's telling us to proceed with caution. In this category are basically programs and initiatives that have been the subject of recent litigation or particular kind of anti-DEI attacks. And there's three main areas I want to flag for you. First, it's demographic targets. So anything that's particularly a numeric target. As we're all familiar, many companies and firms have said, we aim for 25% of X by 2030. That numeric target, many litigants are starting to argue, is akin to a quota, as in the SFFA decision, and in trying to make that analogy. Or they're saying that the only way to accomplish this goal is through a quota. So that's an area that we're seeing. Also, executive comp that is tied to demographic targets is an area of focus right now. Secondly, proxies for protected attributes, that's another area. And I'd like to add to this list programs that are exclusive to underrepresented groups, such as fellowships or internships. And you may have heard about some law firms that were sued for this, and there's some really interesting analysis related to the SFFA that goes in with that. But I'd also like to call your attention to a case before the Supreme Court right now, Muldrow versus City of St. Louis, that depending on the outcome of that decision, could kind of expand employment discrimination claims under Title VII to include, say, professional development or mentorship programs that are focused or exclusive to underrepresented groups. So the key takeaway here is that this yellow category is the area of the greatest activity right now, and where we see a lot of uncertainty, and that uncertainty is creating risk. So maybe turning to the next slide.
Can I just comment on that slide for a second?
Yeah,
so look, I mean, if you are taking race into account expressly in deciding who to hire or who to contract with, that was illegal before SFFA was decided, and it's still illegal. If you had let's say, a bonus program for your divisional vice presidents that said, your salary next year is going to be X, and you will get a bonus of 2X if you increase the number of black people that you hire by 50%. It was illegal then, it's illegal now. If you decide that, we're going to give out contracts, to supply raw materials, and we're only going to give it out this year to companies that are run by unrepresented minorities. It was illegal, it is illegal. The issue of demographic targets, again, the rule of the road, as I understand the case law, is there is a difference between an aspiration and a goal. So for example, PwC has an aspiration that it will have a professional workforce that reflects the full diversity of all of its clients. That's an aspiration, it's not a goal. So long as it is not driving people to take race and ethnicity, qua race and ethnicity, into account, it's okay. And as for the case that is presently before the Supreme Court, just so that you understand the context of it, I read you what Title VII prohibits, which is taking into account race in any employment decision. The courts over the years have restricted what constitutes an adverse employment consequence to be something that has a material effect on your, for example, seniority or salary. In Muldrow, this was a case of a very highly talented senior female police detective who alleged that she was transferred out of her position in intelligence to another division of the police department where she didn't want to work, but she had the same title, the same level of seniority, the same advancement prospects. And the question is that, but she claims that this was because of her gender. And there's a lot of evidence to strongly suggest that she's right. And the question is that an adverse employment context where her salary's not reduced, her prospects aren't reduced, her title isn't reduced? And I think that the Supreme Court, my own take on this is that the Supreme Court will say, yes, that is an adverse employment decision. And I think the point is that if it does that, many more types of programs like mentorship programs that aren't tied to a specific promotion but are designed to help people achieve a level playing field that are directly targeted at race and ethnicity are going to violate Title VII, even though there's no specific articulable benefit for participating in that mentorship program. I mean, the net bottom line is, if you have a DEI program and you want to know where you are in the yellow frame, you need to, this is going to sound like self-promotion, but for our panel, but you need to talk to a lawyer who actually knows about this and can give you an evaluation of the risk profile that a program with certain characteristics has. And this is not going to be some lengthy, complicated, terribly expensive engagement. I mean, any one of the three of us has been doing little since the Harvard decision other than taking a look at what employers are doing and what contractors are doing and say, you can't do this, you can't do this, this is totally fine. On this and this, you might want to phrase it differently, you might want to talk about it internally and externally differently. But this is it's sort of the Wild West out there in terms of threats and litigation. And yet, there is a darn good reason why employers have embraced DEI. Initially, because there were just so many studies showing how much better the businesses fared when they had a genuinely diverse cohort of employees working on things. And then lots and lots of shareholder pressure after the sad events of police misconduct in Minneapolis 5 or 6 years ago. And now the flood of reverse discrimination claims by shareholders and litigators who claim that white men are just being victimized every day.
That's very helpful, and I think that can also take us to the next slide, which aims to offer you all a roadmap for assessing and managing DEI risk. So kind of think of this as a way to manage not just DEI risk, but also opportunities. And I want to kind of clarify that I use the term opportunities very intentionally, because as Seth just mentioned, there's a lot of attention on anti-DEI risks and such, but the reason that we have these DEI programs is because there are risks of withdrawing or failing to advance your DEI programs, and because there are business benefits. And stakeholders have really expressed, stakeholders including investors and current and prospective employees, many have expressed that they want to see progress on DEI. So I kind of think of this in 3 phases. And the first phase is kind of information gathering. And really the first part is that risk assessment that Seth just mentioned. Conduct an inventory of your DEI initiatives and programs and look at how they're structured. Are any exclusive, as Seth mentioned, on the basis of race, ethnicity, et cetera? Think about and take a look at your public disclosures, and including any commitments or pledges that you have made. And then think about how those programs and initiatives and disclosures fall along that risk spectrum that we talked about just before. And consider it also the risks of withdrawing on DEI, and consider kind of your business and reputational risks in that assessment as well. Secondly, within this first phase, monitor DEI legal developments and stakeholder activity, because this is a space that is changing every day. And finally, benchmark against peers, because I think this can help you identify industry best practice and ways to improve. Phase 2, create a DEI action plan. So taking into account that risk assessment, your understanding of recent legal developments, and benchmarking, think about your risks and the benefits of your DEI programs. Again, make sure that you're thinking about the kind of impact of business initiatives, business drivers with respect to DEI and other benefits as well. And use that to help you kind of assess whether any of your DEI initiatives and programs need to be modified, maybe need to be eliminated, or need to be protected. And then phase 3 is kind of to implement that action plan. So establish risk management procedures, ensure that DEI is part of your M&A due diligence, make sure that you establish regular trainings and briefings, and make sure that you're working with a cross-functional team on DEI. So legal and compliance needs to be involved, HR needs to be involved, DEI needs to be involved, your marketing teams, your investor relations teams, all need to be aligned in how they talk about DEI and what gets put out publicly. And that's part of also just the larger investor engagement strategy. So I think here, what I'd like to just express is that being very strategic about understanding and managing your DEI risks and opportunities through this kind of 3-phased approach is hopefully a way to future-proof your DEI program.
This is a terrific slide, and I know as a practitioner, we're all practitioners here in the room. I'm going to take this slide and go back and look at our own DEI program, which we've had in place now for a number of years. Our stakeholders, our employees, called for it through employee surveys and feedback, so it was important to them, and it's been important to the firm, and this is a terrifically helpful and I think practical guide as a roadmap. So I know I'm going to do that. The other thing, I'll ring a bell for the Investment Advisor Association has a terrific DEI working group or committee. That's a great way to benchmark yourself against peers, hear what others are doing, hear what others are thinking. Seth and Sophia and Ron all have made the point, this is a very evolving topic. We've seen 5 articles this week on things that have changed, and it'll probably be 5 more next week with the cases that are happening in the state laws and so forth. So Ron, if you were a practitioner, what would you do at this point?
So, I'll just take a step back and say I come at this panel with a slightly different focus than Seth and Sophia, who have been talking about corporate DEI programs, which are really critical for, the investment advisors in the room. I'm coming at this from the perspective of, what do the investment advisors in this room need to think about from the perspective of DEI investing? There was a panel before this one on ESG investing, and I think much of that discussion applies here. We're going to talk a little bit more about kind of DEI specific regulatory and legislative frameworks, and as well as some of the risk factors that everybody needs to be aware of. So what do I think about? I really think about the risk factors. I think about the regulatory framework, the risk factors, and I think the key for this audience is knowing who your investors are. I think one place to start is maybe to talk about the state legislative trends in the DEI specific context. We've all seen the news about it. We heard some discussion about the state bills in the last panel. Really, I think of state bills as falling into 3 buckets. Some of the state bills touching on DEI investing create reporting obligations. And these are examples, by the way. I think many of the kind of broader ESG state bills apply to DEI investing. These are ones that are specifically a little bit more specific on DEI. So some create reporting obligations. I think an example is the California bill, which obligates venture capital firms to report public company diversity metrics. There's a New York proposed bill, still in the proposal stage, that if passed would require disclosure and considerations of gender wage disparity in state contract awarding. And when I think about state contract awarding, I'm thinking about pension plans that are selecting investment advisors to manage state money. And so those, in my mind, at least come into the scope of this topic. There are other bills that are prohibitive in nature, and those have gotten lots of headlines. Two examples, and these are examples that kind of specifically enumerate DEI factors when they talk more broadly about ESG investing. Two that are prohibitive are Kansas and Indiana. Kansas passed a bill that requires investments solely in the financial interest of the participants and not in furtherance of social, political, and ideological interests. And Indiana prohibits investments for non-financial purposes. The Indiana bill, I think, is leaves a little bit more wiggle room in terms of whether ESG or kind of by virtue of that DEI investing could be for a financial purpose. The Arizona proposed bill prohibits government contracts with companies that participate in DEI programs. It's very specific. I'll notice that, I think I said this before, the Indiana bill and the Kansas bill, when they talk about what ESG is, they very specifically call out factors like instituting or assessing corporate board, employment, composition, compensation, or disclosure criteria that incorporate characteristics that are, essentially protected classes. And then others impose DEI requirements, right? So now we're kind of on the flip side of the pendulum. New York has a proposed bill that would prohibit state contracts with contractors that do not provide health insurance covering services for transgender people. There's a proposed resolution in Louisiana requiring state retirement systems to invest in companies that practice DEI. So you can see how quickly this becomes a very confusing landscape for investment advisors, at least those that are investing state money in kind of trying to understand how these bills that are oftentimes conflicting and contrary, might impact them.
So we've got this changing landscape, and at my firm, I know we have different public plan clients and prospects from states that have different laws or different emerging laws on this. We also have European clients that has a whole different set of laws around ESG and some of the DEI things. So again, as practitioners, Seth, Sophia, what do you do with this?
I mean, look, I think it's important to be clear-eyed with respect to this slide as an example of what legislation is proposed and what legislation actually becomes law, because there is no accounting in any area, subject matter area, for the kinds of legislation that's proposed. I mean, it's astonishing what is actually proposed as legislation. The question is whether it really gets passed. Now, Kansas, Ron was giving the example of this Kansas law. It actually passed, and what it does is require that investments be solely made in the financial interests of participants, not purely for social, political, or ideological reasons. What investment advisor, what firm is going to make an investment on behalf of shareholders or stakeholders that is not in the financial interests of the participants? I mean, if you can say, but you invested in a company that has DEI practices, the answer is yes, because I actually have 1,500 peer-reviewed studies showing that companies that actually do this across the board perform better and have better financial returns. I mean, nobody is going to say, oh, you got me. I actually care about my investors and my shareholders, but I just decided to make a big play for ideological reasons. I mean, that's...
I'll say I think
You don't necessarily go to jail for that, but that's the very definition of not acting in the fiduciary interests of your beneficiaries.
I think that's the challenge. And I think maybe my high-level takeaway, and we can drill down a little bit, is really your fiduciary duty should be your guiding light, right? Because that is really your job as an investment advisor. So I think, Seth, I completely agree. I think the challenge with some of these state bills is they actually go a step further, and they are defining what is the exercise of fiduciary duty. And some of them are doing it to the exclusion of certain factors, which I think is what is causing the risk. And when we think about what the risk is on the state side, I think it's largely the risk of divestment, right? So I think, when you're considering the question that you posed, Louis, what can you do as an investment advisor to manage that risk? It's knowing what money you're managing, knowing whose money you're managing, and knowing what those, where the risk of divestment is. I will say that the state bills are not the only source of risk, right? You've got SEC greenwashing claim risks. You've got the DOL rule, which I think is a bit easier to kind of make the case that you're exercising your fiduciary duty when you're considering, DEI as part of risk-based returns assessment, risk-adjusted returns assessment. And then there's, of course, the challenges around private litigation. There's a class action case right now that's going kind of up and down in terms of motions to dismiss and summary judgment motions against American Airlines, where investment advisor, the fiduciaries to the state, to the employee sponsored benefit plan, has challenged, right, the investment options that are being made available to the participants on this basis. So there's the state risk, there's the SEC risk, there's the DOL risk, and there's private litigation risk. And I just think knowing and understanding where, which of those risks come into play, and then knowing who your audience is critical.
And we all live in the regulated industry with the SEC, and you used to sit in the enforcement seat. And so wearing your enforcement hat or your former enforcement hat, how would you, what lens do you put on this particular discussion?
Yeah, the SEC focus really, and there have been no SEC enforcement cases specifically touching on DEI investing, but the SEC focus on greenwashing for DEI investing would be no different than ESG investing, right? It's the same considerations, and the SEC's focus is, what are you saying you're doing? What are you actually doing? And how is your compliance program kind of overseeing all of that to make sure that you are doing what you're saying? And so, I think much like the panelists on the last panel, the key is knowing all of the above. For the compliance professionals in the room, you need to have a seat at the table in order to exercise, your obligations. And I will say that the SEC has been willing to bring standalone compliance rule failure cases. The Goldman Sachs case is an example of that. A pretty hefty fine for a standalone compliance rule failure involving ESG investing.
We're getting some great questions. Please keep them coming. Sophia, what do you make of all this? Where would you take this as a practitioner?
Well, our client base is quite large, so that helps us get a really great sense of the market. And in terms of what we're seeing investors ask about, I'd say that the majority are still kind of demanding more transparency and demanding kind of that firms and funds advance DEI through their DDQs and side letter requests, et cetera. So we aren't seeing, for the most part, a kind of a pullback from investors on DEI. But that said, when we're dealing with a pension from say Kansas or something like that, they do have to work within the bounds of these anti-ESG laws that have DEI implications. And so it becomes, I think, really important to work with counsel in those negotiations. I think the last session kind of touched upon this as well, thinking about how to negotiate between, say, an investor base that is in Europe and wants to see more transparency, more work on DEI, et cetera, and maybe a pension fund from Kansas. Working with counsel in those negotiations to carefully craft side letters or certifications, I think can be really quite helpful, because I think there is a way to reconcile these things most of the time.
I think that's right. Again, it is in our seat. I think it comes down to two key things. We are a fiduciary first and foremost, and we have to keep that in mind at all times. And I think you've heard that loud and clear from the panelists. The other thing is disclosure, right? Say what you do, stick to it. If you vary from that, you need to change your disclosure, you need to change your practice. And a bunch of these, whether enforcement cases or certainly some of the litigation has called out shortcomings in that regard. Here's a good question. Many investment management firms, especially those who work with institutional clients, have a client that requires a certain percentage of their accounts brokerage to be placed with minority brokers. That's a pretty common provision for public pension plans from certain states. Some advisors themselves have brokerage commission targets in terms of a percentage of the commissions they place for minority and women-owned brokers. How does this impact all of that?
Again, I think knowing who you're managing your state money for, right? I mean, I think it's really critical. When I think about the fiduciary duty, the exercise of one's fiduciary duty, it's really, you need to know what your client's objectives are. I think that's, and then let your investment advice and your practices be guided by that. I think it's maybe a little bit easier when you are kind of managing money for an individual, right? Not institutional clients. Or let me put that slightly differently. When you're managing money for individual clients and not on a kind of pooled investment basis. Because again, you've got an individual client, you do your meetings, you know what their investment objectives are, you know whether or not DEI fits into that and how. And I think that's really the appropriate exercise of fiduciary duty. When you're managing pooled money, that becomes much more difficult, right? You may have one investor, one kind of LP, who says, I want X, and the other says, I want none of X. And so in that context, I think side letters, parallel strategies can be really helpful. And I think it's not just about your individual investment decision-making on a asset by asset basis. You think about stewardship, and that becomes even more complex, right? How do you exercise how do you vote your proxies, right? For some investors in a way that may conflict with what other investors want. And I think you have to, create paths in your investment products for all of your investors to have, to be able to kind of have their needs satisfied.
Sophia, Seth, anything to add on that?
I mean, if you're investing in, I think your original example was investing in a company that, for example, requires that 25% of the accounts be minority, fill in the blank. I mean, there may be lots of good investment reasons for you to like the performance of that company, but it is a financial risk. That practice, which violates 1981, poses a legal and therefore a financial and reputational risk for that fund or that operator. And it's not as if you are prohibited by law from investing in a company that does this. You just have to recognize that there is a legal risk to that company and hence to your investment.
Yeah.
And we all live with the best execution standard, right, which sits on top of everything. So you can't use your brokerage commissions, which are client assets, to trade with a broker if that is not consistent with the principles of best execution, no matter what reason.
That's a great point.
And just to piggyback off of that, I think Section 1981 is really critical to look at because it as Seth mentioned, it prohibits discrimination on the basis of race in private contract matters. Now, Section 1981 is from the Civil Rights Act of 1866. So just some legal history, it was intended to prohibit discrimination against former slaves and has been used in this recent post-SFFA wave of litigation as the basis for so-called reverse discrimination claims. And it's these kinds of investment practices that might be vulnerable now as a result of kind of the growing use of Section 1981. And there's a case you've probably heard of, the Fearless Fund case involving a venture capital fund. And that's now at the circuit level we're seeing where that case could go. But I do agree with Seth, there's a really growing risk with those kinds of strategies, and that's why it's so important to work with counsel and make sure that you've assessed those risks and that maybe you have really considered your risk tolerance with that kind of strategy.
Yeah, it seems to me that's in the yellow box and maybe moving off to the red box. Here's an employment question. If I choose not to if I'm applying for a job and I choose not to disclose within the race ethnicity, could companies give me less consideration legally, and might companies do that?
I mean, companies are prohibited from using race or ethnicity in and of itself as a decisional factor. So the way that many companies are dealing, and there are, I can't underscore how easy it is for companies to satisfy their DEI hiring aspirations without taking race or ethnicity or gender for their own sake as the decisional means. There isn't enough time, but I could rattle off any number of ways. I mean, you look at the way that universities now are doing it. There's no university in the country that is now allowing its admissions committee to see the self-identified race or gender of the individual. They just don't see it because the Supreme Court has said you can't do that. They can very easily ask a question saying, tell me something about your prior experience, your life experiences that has made you, that has been critical in making up who you are. Tell me what involvement, if any, you've had in promoting DEI, whether through developing a program or, in your university, in your educational setting. It's not because I'm a black person that by definition I'm doing this. There's so many easy ways to do it, but you can't. A company could not say, you're not going to get considered because you wouldn't check the box. I mean, maybe they could say, you're not a rule follower. We only want employees who follow rules, and you didn't check the box, and by the way, you also didn't, put down the right zip code of your home, therefore, you're not the kind of careful employee that we want. But a failure to disclose race or ethnicity or gender, for that matter, can't possibly be a viable reason for making employment decisions.
Here's another good one. 2 questions along the same line. If a separately managed account client, so an institutional client, wants to see DEI at my firm reflected in a diverse workforce, is that impacted by these recent developments? So my clients are calling for a diverse workforce and asking me for information about my workforce and what I'm doing about it.
You mean the investment advisors workforce?
Correct.
It's a Seth Sophia question.
Well, that's kind of what I mentioned before. We are seeing a lot of investors through DDQs, through kind of investor relations, ask to see more transparency on DEI and ask to really kind of put some pressure on wanting to see those firms advance their DEI programs. So I think one point we haven't talked about much today, but I think it kind of relates to this and responding to investors, is data collection. A lot of our clients have asked, is it okay in this post-SFFA world to collect data or report on our workforce? And I just want to emphasize that data collection is perfectly legal and is really quite critical for these kinds of investor relations kind of aspects, but also to kind of explain the business case, explain why your program is the way it is. It's informational and low risk. So, but we're seeing that on the ESG side of things, all kinds of questionnaires and such asking for information like that. That's really kind of common in the market and low risk to engage in.
I mean, there are any number of government programs that require reporting about this. I mean, at the same time that colleges can now no longer take race into account in making, at least race qua race into account in making admissions decisions, the Department of Education requires all universities that receive federal funds to report the racial, ethnic, and gender breakdown of each matriculating class. So, and look, if I were important and significant enough that I needed a separately managed account and I was picking an investment advisor firm, I would say, look, I'm very familiar with the social science data here. I would like to have the most effective firm that I can, and I understand that a firm that itself reflects diversity of backgrounds and opinions is likely to get me over time a better return and see better opportunities for me. You know, of course this is a basis on which companies can compete.
There we go. Panel, this is a great group. Thank you all.
Thanks.